We are talking about rulings that could fundamentally alter the absolute bedrock of American governance and society as we know it. Let's dive right into this explainer and unpack exactly what is about to happen. Together, these impending rulings could permanently restructure three massive pillars of American life. We're looking at who holds power over the massive government bureaucracy, the independence of our economy's referees, and even who legally counts as an American citizen from birth. The stakes literally could not be higher. Section 1. The Exhausted Majority, Decoding the Legal Fine Print. I'm Brian, and for over a decade now, I've moderated ideologically diverse political debate communities. I've spent thousands of hours listening to voices from across the full political spectrum, from the far left to the far right and everywhere in between. That specific experience of actually listening to everyday people is exactly why I built this explainer. It's totally dedicated to informing and empowering what I like to call the exhausted majority. We just want to cut through all the partisan spin and look at the hard facts. And honestly, this mission is why analyzing these specific Supreme Court cases matters so much to all of us right now. Case 1. Trump v. Slaughter and the War on the Deep State. This case threatens to completely upend how the government has functioned for nearly a century. You see, for almost 100 years, the machinery of our federal government has depended on something most of us have just totally taken for granted, and that's independent agencies. Bodies like the Federal Trade Commission and the Federal Reserve were specifically designed by Congress to operate as technocratic shields against political whiplash. The whole idea is that they protect your consumer data, your savings, and stable interest rates from the sudden impulses of whoever happens to be sitting in the Oval Office at any given time. Well, Trump v. Slaughter is a direct frontal assault on that entire framework. The administration's argument here rests on what legal scholars call the unitary executive theory. Now, this is the idea that the president has total, unreviewable control over every single person working anywhere in the executive branch. In their view, if you work for the executive branch, you answer directly and solely to the president. Period. But to actually pull that off, they need the court to overturn a massive precedent. Back in 1935, during FDR's administration, the Supreme Court unanimously decided a landmark case called Humphrey's Executor. It established that agency heads actually have for-cause protections. That basically means the president cannot just fire them without a genuine reason, like neglect of duty or actual illegal activity. While the administration's goal in Trump v. Slaughter is to totally overturn that precedent, arguing the president should be able to fire any agency head at will. Think about it. Right now, the president cannot fire the chair of the Federal Reserve just because they don't like what interest rates are doing to their poll numbers. But if the administration wins this case, any president can. Let's put this into concrete terms, right? The Federal Trade Commission, or FTC, is the agency that literally stops your internet provider from secretly selling your browsing history. The Consumer Financial Protection Bureau blocked predatory payday lending schemes that were targeting working families. And the Federal Reserve? They set the benchmark interest rate that directly ripples through your mortgage, your car loan, and your small business line of credit. So here is the absolutely crucial point to take away from this. These are not just abstract, boring bureaucracies. They are the referees of your financial life. If the president can fire any of them the very moment they make a call he doesn't like, the whole game changes completely. Every single decision these agencies make would suddenly be viewed through a highly political lens. Next up, the threat to independence in Trump v. Cook. To really understand the stakes here, we have to look at a closely related shadow docket case, Trump v. Cook. Recently, the administration attempted to quickly remove Federal Reserve Governor Lisa Cook, citing pre-appointment mortgage application discrepancies as a quote-unquote for-cause reason. Now, these are allegations Governor Cook vigorously denies, but this move triggered worldwide alarm from economists and even visible hesitation from conservative justices on the Supreme Court. And there's a big historical reason for the court's hesitation, because we've seen the potential impact of executive pressure on the Fed before, back in the 1970s. The Nixon administration heavily pressured the Federal Reserve to cut interest rates heading into his 1972 re-election campaign. They wanted to juice an already strong economy that didn't actually need the stimulus. The result? The economy overheated. What followed was a full decade of crippling stagflation. It literally took Federal Reserve Chairman Paul Volcker deliberately triggering a painful recession in the early 1980s just to finally break that inflationary cycle. What Volcker did took extraordinary courage. It was incredibly unpopular at the time. But here's the thing. It was only possible because Volcker didn't answer to a politician facing an upcoming election. No elected official would ever risk their career that way, and that is the entire point of having independence. This brings us to the defining legal challenge of these intertwined cases. Can the court protect the Federal Reserve's unique independence while simultaneously handing the president at-will firing power over the FTC, the FCC, and every other independent agency? Threading that needle, if it can even be threaded without creating a massive legal contradiction, is going to be the most consequential legal maneuver in this entire ruling. Today, we're looking at Case 2, Defining the Citizen, formerly known as Trump v. Barbara. Now this one, it's the undisputed blockbuster of the term. The stakes are absolutely massive, and we're going to break down exactly why this case has everybody paying attention. Section 1. The undisputed blockbuster. And it's a historic first at the Supreme Court, with the president himself actually attending the oral arguments. Section 2. Executive Order 1460, challenging birthright citizenship. At the heart of this case is an executive order attempting to deny birthright citizenship to specific children born right here on U.S. soil. Specifically, this order targets two groups: children of unauthorized immigrants and children of parents here on temporary visas. The core idea is to deny citizenship based entirely on the demographics and legal status of the parents at the exact moment of their child's birth. But this sets up a massive constitutional collision course with the 14th Amendment's Citizenship Clause. That language was written right after the Civil War, and its specific historical purpose was to ensure the United States would never again create a permanent legal underclass of people who were born on American soil but denied basic human rights. Section 3. Two legal theories. The court is weighing a century and a half of settled law against a radically different interpretation. We're looking at two main arguments here, without the partisan spin. First is the revisionist view, which treats citizenship like a mutual social compact, requiring full political allegiance. Under this theory, entering the country without authorization is an act of defiance, so the parents, and by extension their newborn child, never entered that compact in the first place. On the flip side is the originalist view, championed by conservative scholars like Keith Whittington. They argue that being subject to the jurisdiction simply means you are under the authority and protection of U.S. law. Think about it. If you break a law here, you face our courts, you serve time in our prisons. To back up that originalist view, we have to look at history. Historically, the only exceptions to birthright citizenship were children of invading armies or foreign diplomats. Why? Because diplomats have sovereign immunity and literally cannot be prosecuted under our laws. But unauthorized immigrants? They have no such immunity, none. They are entirely subject to our laws and our jurisdiction. Section 4. The human stakes. Because beyond the abstract legal theories, we really need to look at what this means for actual people. I want you to imagine a child born in a local suburban hospital. They grew up playing for your neighborhood Little League team. They attend American public schools, they speak English as their first language, and they literally know no other home. This is a deeply relatable profile for millions of families across the country. But here's the catch. If the revisionist view prevails, legal analysts point out that hundreds of thousands of these exact children could face a permanent legal limbo. They'd be born here, but effectively stateless, with no country to call their own. Section 5. A systemic catastrophe and bureaucracy breaking down. Because we're not just talking about a minor administrative tweak here. Implementing this would enable enforcement actions on a scale this country has never attempted. We are talking mass deportations, mass detention, and widespread family separation. The sheer logistics of enforcement alone would be staggering. Right now, there is absolutely zero system in place to determine a newborn baby's citizenship based on their parents' immigration paperwork at the hospital. Think about the local institutions, hospitals, courts, schools, local governments. They would all be left completely paralyzed with no federal guidance and no government infrastructure to sort out who is a citizen and who isn't. And the ripple effects don't stop there. It actually puts the voting eligibility of every single American in doubt, because suddenly your standard birth certificate is no longer sufficient proof of your citizenship. Imagine what that means the next time you go to register to vote. And the consequences for adults are just as massive. Adults born to unauthorized immigrants, or even to parents who were just here on temporary visas decades ago, could have their citizenship stripped entirely. And right now, there is no voter registration system capable of handling that kind of systemic shock. To put all of this into a real-world perspective, last year, I had to wait over 2 months just to renew a simple expired passport, all because federal staffing cuts had gutted the State Department's processing capacity. Now take that exact bureaucratic headache and multiply it by millions of lifelong Americans suddenly forced to reprove a citizenship that was never even up for debate before. The source material warns this would trigger a systemic catastrophe that our current infrastructure simply cannot handle. So, if Trump v. Barbara redefines who even counts as an American, what exactly comes next? Well, our final case redefines the entire balance between individual rights and private property. Thanks for joining me on this explainer, and definitely stick around as we dive into that next critical decision. Today, we are unpacking a truly massive shift happening right beneath our feet in American law. We're talking about the Supreme Court's latest term and how a handful of key decisions are, well, they're essentially rewiring the balance of power in the United States. Let's look at Case 3, the Vampire Rule and Gun Rights, officially known as Wolfrod v. Lopez. So this case is fascinating because it sets up a head-on collision between two values that so many of us, what you might call the exhausted majority, actually hold at the exact same time. We're talking about Second Amendment rights on one side and private property rights on the other. To get what's going on here, you've got to understand the Vampire Rule. It's basically the idea that a gun owner has to get explicit advanced permission from a property owner before they can carry a weapon onto private property that's open to the public. It literally operates like the old folklore, like a vampire needing a formal invitation just to cross your threshold. And hey, this is not just some niche issue, not at all. These laws currently apply to over 86 million people. That's a huge chunk of the country, covering states like Hawaii, California, Maryland, New York, and New Jersey. But here's the thing, the landscape is shifting fast. During oral arguments, the conservative majority on the court signaled some serious skepticism, relying on the recent Brune and Rahami rulings. Because of that, it looks very likely that they are going to flip the default entirely. Instead of permission being required, we're looking at a future where guns are just automatically permitted everywhere, unless a business owner actively puts up a sign to keep them out. So, what does this actually mean in the real world? What is this asking of a local business owner? Think about a restaurant operator in Newark or Honolulu. If she doesn't want firearms in her dining room during a chaotic Saturday morning breakfast rush, she suddenly has a brand new burden on her shoulders. In those 5 states, that owner is basically forced to make a very public political statement just to keep the exact same baseline she had last week. She might face blowback, online attacks, or even lose customers simply because she wants what business owners in 45 other states already have by default. And what's that? Just the peaceful right to stay entirely out of the culture war. 45 states already operate perfectly fine without this rule, so the specific outcome here might not cause massive drama everywhere. But, and this is a big but, what should really concern all of us, no matter your politics, is the underlying pattern. We are watching a federal court override state and local authority that has historically been respected under the 10th Amendment. And you know what? That exact pattern connects all 3 of the major cases we've looked at. Which brings us to the big picture, the Republic Reconfigured. When you step back and look at these together, it is crystal clear. 3 cases, all pointing in one direction. Slaughter expands executive control over the professional civil service. Barbara narrows who legally belongs to the American body politic. And Wolfrod federalizes a domain that states and local communities have governed for a very long time. So here's the absolute crucial takeaway. Every single arrow is pointing in the exact same direction. We are seeing power concentrating upward. It's moving away from local communities, away from institutional checks, and heading straight toward a presidency with fewer constraints than any we've seen in modern American history. And this shift, it has sparked a massive reaction from the bench. The court's liberal justices, Jackson, Sotomayor, and Kagan, they aren't just dissenting here, they are sounding alarms. They're writing opinions less for today's courtroom and much more for tomorrow's history books. Specifically, they are taking aim at the court's expanding use of the interim docket, which you might know as the shadow docket. This is an expedited process that lets the administration push through sweeping structural changes using emergency orders long before any full judicial review can actually happen. It completely bypasses the normal legal process. Just think about how this plays out. Step 1, no full legal briefings for the justices. Step 2, absolutely zero public scrutiny of the arguments. Step 3, no transparent accountability. And finally, Step 4, an emergency order gets issued before a single oral argument is even heard. It's wild. What we're ultimately watching here is a Roberts court that, sure, occasionally checks the executive branch on specific policies like we saw with the recent tariff disputes, but structurally, it appears fully prepared to ratify vastly expanded Article 2 presidential power over the entire American experiment. And this pattern of federal overreach, it's something that really should alarm everyone, left, right, or center. It's actually a complete role reversal. Small government conservatives, who have spent literally decades warning about federal overreach, should find this just as troubling as progressive critics do. The irony of these shifting traditional roles is pretty striking, isn't it? But ultimately, the demand for accountability is still there. The exhausted majority didn't get here by giving up, and we're sure not starting now. So, the question we leave you with is this. As power continues to concentrate upward, how will these massive structural shifts alter the way our local communities govern themselves in the years to come? That is the vital question we all need to be asking. Which brings us to our final part, Section 5, the balance of power. When you zoom out and actually connect the dots across all three of these remaining cases, a really distinct pattern emerges. Together, these rulings are testing our institutional guardrails and fundamentally redefining the American system of checks and balances. Roughly 58% of Americans disapprove of where this country's political leadership is headed. Whether you're center-left, center-right, or just someone exhausted by a system designed to make reasonable people give up, it is tempting to look at all of this and throw your hands up. Don't. That's exactly what the partisan fringes are counting on. These decisions will reshape our civil service, our definition of citizenship, and our public spaces. When you walk into a voting booth, your choice cannot be about screaming headlines or culture war theater. It has to be about electing people who genuinely respect institutional guardrails, long-term stability, and the foundational principle that no single branch of government should concentrate this much authority without constitutional checks or public accountability. We are not the alternative. We are the exhausted majority, and we hold the power. We just have to stand up and exercise it at the ballot box, and we are the ones who have to fit the puzzle pieces of this country back together again when the extremes are tearing it apart. If these rulings have you wondering how we fix the system that keeps producing them, click right up here where I look at the gerrymandering crisis from both sides and lay out the reform ideas that could make Congress actually represent people like us. Congress is where this fight ultimately has to be won. Which of these three decisions worries you the most? Drop it in the comments, I read and respond. If this kind of commentary, the kind that examines the legal fine print instead of echoing the loudest pundits, is useful to you, please gently tap that like button, subscribe, and share. Stay sane, keep them honest, never lose hope.